Hello, everybody. Welcome back to English Law. So, I want to talk about involuntary manslaughter now. So, manslaughter is is killing another human being accidentally. Anyway, so there are three types of involuntary manslaughter. They're foresight or reckless manslaughter. That's one type. The second one is unlawful manslaughter, sometimes called constructive manslaughter. And the third one is gross negligence manslaughter, which is when you cause someone's death through omissions, when you're supposed to care for them and you do not care for them adequately. Okay, so the tricky thing is there is considerable overlap between them. Take Hyam, that case 1975, or Smith 1961. In both cases, these people killed others while doing something very perilous. Remember, Miss Hyam, she had the bright idea of scaring away her rival in love by setting fire to her love rival's house. The basis would scare that woman away, and then Miss Hyam could marry that woman's husband. But the best laid plans of mice and men gang aft awry, and Hyam managed to burn the woman's 3 children to death, which obviously did not endear Miss Hyam to the husband. Anyway, so in Smith, he drove his car in an attempt to get a police officer to run away. The police officer there to arrest him, and the policeman was hit and killed. So the defendants were not charged with murder, because remember, murder requires intention to kill or cause grievous bodily harm. Seems to me, Smith, surely that was murder. But anyway, reckless manslaughter, that will operate if the prosecution can demonstrate that the person foresaw that death or serious injury was going to result. Gross negligence manslaughter, that is, doesn't matter whether the prosecution can show foresight of death or serious injury, but the jury would consider these acts to be grossly negligent as to whether there was a chance someone was going to die or not. Constructive manslaughter. In both cases, the defendants would kill people whilst they're doing something which was illegal and perilous. Right. So the prosecution, they usually charge whichever type of manslaughter they think is the lowest evidential burden. Constructive manslaughter usually because, as they say, it's constructed out of the others, right? Okay, so let's see how distinctive these things are. Anyway, reckless manslaughter is seldom charged because you're acting with the foresight that death or major injury will result. In most cases, reckless manslaughter was constructive manslaughter, i.e. an unlawful act manslaughter. Reckless manslaughter is used when the defendant is charged with murder and the judge tells the jury, no, we have to find the defendant guilty of manslaughter if you're not persuaded that there was the intention necessary to convict the defendant, because the defendant didn't foresee death or serious injury was likely to result from his act. There are examples of this: Hyam 1975, Goodfellow 1986, Hancock and Shanklin 1985. So we all know that this is about reckless manslaughter. Constructive manslaughter is the right thing to charge where there's evidence that the death arose from an unlawful act, an act which is objectively dangerous, but there's not enough evidence to show that the defendant intended or foresaw that death or a serious wound would result, or perhaps was grossly negligent as to the chance that death would follow. Okay, so there's constructive manslaughter. If you you punch somebody and then they die from that, you wouldn't expect someone to die from that. So that's actually not murder. Because it's not the other two forms of manslaughter, because the assailant who punches a man, who then dies as a result, didn't think that death or grievous bodily harm was going to result. He wasn't grossly negligent of the risk of death. He didn't have some sort of duty of care towards that person. So gross negligence manslaughter is the right charge where there isn't enough evidence that the defendant foresaw that death or serious injury was likely to be consequent upon his behaviour. Anyway, so the gross negligence is about those who kill someone whilst they're doing something legal, like performing their duties as a doctor, nurse, police officer, parent, or whatever. But they're so careless that this is criminous. So the almost complete lack of diligence is what makes it a crime. It can be an omission, failing to do what they ought to have done. Train drivers who ignore signals, incompetent electricians who cause people to be electrocuted, construction workers who don't follow building regulations and cause death that way. Okay, right, constructive manslaughter. So this is sometimes called unlawful manslaughter because the liability here doesn't arise from the actus reus and the mens rea, because there's no consequence in the mental state. The liability of this crime is constructed out of other aspects of it. For instance, you can be guilty of manslaughter if the death results from doing an act, criminal damage, burglary, robbery, or even theft. So the prosecution has to prove the following: that the elements of the core offence, for example, the assault, the criminal damage, the objective likelihood that harm would flow from the commission of that act, and lastly, that there was a cause and effect relationship between the offence committed and the death that followed. So, we don't want to overstate the level of wrongdoing here. Anyway, let's have a look at the actus reus for constructive manslaughter. So there has got to be an action. So, and the act must cause the death. So this cannot be committed by omission. Omissions are not enough even when there's duty of care. Lowe 1973 was a case about this. The defendant was charged with constructive manslaughter because he had neglected his child terribly. He was found guilty because he caused his the child's death through this crime of not looking after the child. That was the willful neglect of a child, as per Section 1 of the Children and Young Persons Act 1933. But the defendant's conviction was overturned on appeal. The Court of Appeal said that you must have an act for constructive manslaughter. It cannot be an omission. This constructive manslaughter would have been the right charge if he'd caned his son so severely he died. Look at a case called Chancellor from about 1860, where a teacher beat his child to death. Okay, so there were no actions proven in this case in Lowe that caused the child's death. So it should have been gross negligence manslaughter. So the prosecution, they charged constructive manslaughter because they thought it was simpler to show the commission of Section 1 offence than it was to demonstrate gross negligence. Anyway, so remember, in constructive manslaughter, the act must be a crime. Look at Franklin 1983. In this case, a man, he threw a wooden crate off a pier, then not wanting to harm anyone or being aware there was a risk to anyone, but that crate hit someone swimming in the sea and killed the swimmer. So the defendant, he was found guilty of constructive manslaughter. However, on appeal, that was quashed because what he had done was not a crime. It's not a crime to throw a wooden crate into the sea. I wasn't aiming at anyone. Was just terribly unlucky. Okay, so in constructive manslaughter, you've got to say, was the original action a crime? And if it wasn't, it can't be constructive manslaughter. Okay, and which crime that is, the prosecution has to say. Is it criminal damage or what? Jennings 1990 is a case where that was laid out. There's another important case called Larkin 1943. Well, there's one called Lamb 1967. And these are leading cases for the idea the prosecution has to be able to prove all aspects of the crime to get a conviction for constructive manslaughter. The prosecution's task goes further. If the defendant is a defence to that core offence, the offence which actually caused the death, if there was consent or self-defence, then the person can't be convicted. So Scarlett, 1993, was a case where a publican had to get a rowdy drunkard out of his ale house. He pushed the guy out. The drunk fell down, fractured his skull on the street, and died. So anyway, the publican, he was found guilty of constructive manslaughter. But then on appeal, it was overturned because he was performing a lawful duty, as in preventing this disorderly behaviour in his pub, pushing the person out. It was proportionate force. It was just incredibly unlucky the guy fell over backwards, hit his head, and died from that. Because there was no crime originally. It was a reasonable use of force. It was self-defensive. Inevitably, you have to eject people from pubs from time to time. All right, constructive manslaughter, they're crimes of negligence, but these are qualified. There are some activities which, if done, are allowed by law, if done properly, but are illegal if performed dangerously and negligently. Driving would be a key example. If a driver kill someone through speeding or driving under the influence of alcohol or whatever, or dangerous driving, then that's a crime. So, but is the defendant guilty of constructive manslaughter? Well, it depends. A lot of people on just how badly he's doing it, and was there any contributory negligence by the victim? So we don't want to take over the gross negligence manslaughter, making the convictions too easy. Andrews 1937 was a case about this, where the House of Lords said that only acts which are criminal in themselves can be the core of constructive manslaughter cases. So if what you're doing is legal generally, but criminal only because you performed it so badly, as in driving, but driving dangerously or driving drunk, then the prosecution has to charge gross negligence manslaughter. They cannot charge constructive manslaughter. All right, there are other things to bear in mind. So the prosecution has to prove the carelessness and the dangerousness of the crime. Okay, so in constructive manslaughter, remember that the action must be dangerous. It doesn't have to necessarily mean that it was life-threatening, but it means of something that would cause some harm. So we know that punching people is dangerous. It results in some injury, even if it's trifling. If the punch is a core activity, then that could cause death. Church 1966 was a case about this. Lord Justice Edmund Davies heard the case, and he gave, this is the seminal definition of a dangerous act. The act must be such that all sober and reasonable people would inevitably recognise the subject. It must be subject to the other person to at least a risk of some harm resulting therefrom, albeit not serious harm. Close quotation. Here, when it says the other person, that means the person who gets hit. Now, the action doesn't have to be directed against the victim, could be directed against somebody else, but actually ends up hurting the victim. Mitchell 1983 was a case about this. You might remember people are queuing in the post office. There's a row about is someone queue jumping. One man shoves another, which caused this man to fall on top of a woman and kill her. Okay, we know that shoving a person is going to cause harm, and that harmful act was not directed at the victim who died. Nevertheless, there was liability. Okay, so anyway, there are different cases here where the same action will show that it's hard to say what's a dangerous act and what's not. In Dawson 1985, a defendant, he pointed a toy gun, a quite convincing looking toy gun, at a victim during a robbery. The victim had a terrible heart condition. He suffered a heart attack and died. So the defendant was found guilty of constructive manslaughter, but then he appealed, and his appeal was allowed because the judge should have told the jury to convict only if they believe that pointing a gun at someone was objectively dangerous, or if it was a toy gun. The victim didn't know it was a toy gun. The whole reason is frightened because the replica was so realistic. So it would only be objectively dangerous to point a toy gun at someone if you knew that he had a dicky heart. We'll come on to Watson 1989. Here a defendant, he carried out a burglary on a house where an 87-year-old was living. The 87-year-old had a heart history as long as your arm. So there was some sort of, what shall I say, face-off between them. And the old man was very frightened. He had a heart attack and died sometime later. The defendant was found guilty of manslaughter. Then he appealed. He was let off for other reasons. But anyway, the Court of Appeal said that, going by the church definition, the defendant's encounter with the elderly man was not objectively dangerous. But as the household, it was not objectively dangerous. But when it was clear he was so elderly and frail, then it became dangerous. Carrying on with the burglary after he realised this, that made it a dangerous act. Okay, and remember that this act, it must be the thing which results in death. It can't be something else which causes the death. So causation is problematic. Anyway, there's the but-for rule. The but for the defendant's act, the person wouldn't have died. But for the burglar breaking into the house, the old man wouldn't have had the heart attack when he did. So the remember that the defendant's action must be a substantial or operating cause. Anyway, which if not wouldn't have happened without that. So if something else comes along and removes D's act of all its causal potency, then that's different. That breaks the chain of causation because it supersedes the defendant's action. Okay, let's go to causal sequence. This is in supplying illegal drugs. So we know that selling certain drugs without a license is against the law and is dangerous as per the church definition. So the defendant sells or gives for free these narcotics. The victim injects herself and then dies. But the defendant supplied the drugs is not guilty of manslaughter because the chain of causation is broken because the victim injected herself. That's Kennedy number 2, 2007. Unless, of course, the person lacks capacity, is in a minor, for example. So, however, if the defendant injects the victim, even with the victim's consent, then the defendant is still guilty of constructive manslaughter. Okay, so it's not supplying the drugs which is the basis of the charge, but injecting them, administering them, because the defendant is liable because there was no later act that intervened. No novus actus interveniens, the cause of church, because the chain of causation is intact. Look at Cato 1976. Right. Another vexed issue here is the actions of the defendant to the victim. Where the victim commits suicide, for example. What's causation? Where you say you take your victim as you found him. Blauer, there's the test for the foresight. Roberts, was it a daft or disproportionate action? Williams is a voluntary act test, or the way it was decided in Kennedy, or perhaps Wallace, where the Court of Appeal, they dodged the issue, and they said that the question to be looked at in every case is whether more than one cause led to the death. And they said, the accused acts can fairly be said to have made a significant contribution to the victim's death, close quotation. So if it makes at least a significant contribution, then it will operate. Now, what's the mens rea here? The mens rea is constructive liability. The defendant is held liable for the crime on the basis of the crime of constructive manslaughter because they committed that earlier crime which led to the death. So if the defendant is charged with constructive manslaughter because he's committed another crime, like, I don't know, assault or whatever, administering drugs, then we don't think about proof of causation for a minute. You have to show that the actus reus here, the guilty act, as in punching somebody or injecting them with drugs or whatever. You also have to show that there's a mens rea here for assault or to supply illegal drugs. And so that is intending or foreseeing or being reckless to any sort of unlawful act and harm that would follow. Okay, so that's enough on that one for a minute. Toodaloo.